You know, we've all heard those classic neighborhood stories, right? Well, today we're diving headfirst into one. It's a real showdown. One homeowner's vision for his own backyard versus the rules of his community. And believe it or not, this whole thing ended up in court, all because of a 5-foot wall.
So that really brings up a huge question, doesn't it? Can your HOA really tell you what you can and can't build on your own property? It's a tricky one. And to get to the bottom of it, we're going to look at a real-life case, Jeffrey Audette versus the Sun Harbor Community Association. Let's set the scene.
Okay, so picture this, a beautiful waterfront community in Peoria, Arizona. We're talking gorgeous views, right on Desert Harbor Lake. Our homeowner, Mr. Audette, has a prime spot. And right there, near the shoreline, is the one thing that started this whole mess, a brand new wall.
And wow, what a change it was. I mean, look at the before and after here. Originally, you had this classic wrought iron fence, open, airy, you could see the beautiful lake right through it. But then, Mr. Audette decides to replace it with a solid 5-foot-high block wall. It's in the exact same spot, right within that 15-foot zone from the lake, but the vibe, totally different. We're talking a massive view-blocking structure now.
All right, and this is where the plot really thickens. Because to understand how this whole thing blew up, you absolutely have to look at the order in which things happened. Okay, so let's walk through this. In February 2018, Mr. Audette goes ahead and builds the walls. Then, in March, a month later, he submits the paperwork asking for approval. See the problem? The construction was already done. Of course, the HOA's architectural committee says no. The HOA board backs them up, and things just escalate from there. Until, bam, more than a year later, we've got a full-blown lawsuit.
Now, Mr. Audette wasn't just going to roll over and accept this. From his point of view, the HOA was being totally unreasonable, and he was ready to fight for his wall.
So what was his case? Well, he laid out a few key arguments. First, he said, hey, my next-door neighbors, they're totally cool with it. Second, he claimed he actually did get the green light from his smaller local sub-association. He even pointed out that, usually, the big HOA just rubber stamps whatever the sub-association approves. And for his final point, he brought photos, basically saying, look at all these other houses in the neighborhood breaking the rules. And all of this was building up to one big legal accusation, selective enforcement. Basically, he was arguing that the HOA was picking on him, making an example out of him, while turning a blind eye to other people doing similar things. Why me? Of course, there are two sides to every story. And the Sun Harbor HOA, well, they had a completely different perspective. For them, this wasn't just about Mr. Audette's wall. It was about protecting the feel of the entire community.
And this quote really says it all. They argued the wall was inharmonious with the surroundings and obscured the view of the lake. In other words, it just didn't fit. It went against that open, airy, lakefront vibe they were trying to maintain. And critically, it wasn't just about his view. It was about blocking the view for everyone.
So the HOA's counterargument was pretty straightforward. Point 1, the rulebook is crystal clear. No solid structures over 3 feet in that specific zone, period. Point 2, you've got to get written approval before you build, which, he didn't. 3, they argued that nobody else had done anything this drastic, swapping a see-through fence for a giant block wall. And finally, and this is a big one for any HOA, they were worried about setting a bad precedent. If they let this slide, what's stopping the whole shoreline from becoming a wall?
Okay, so you've got strong arguments on both sides, right? This is where the judge has to step in and look at the actual letter of the law.
First thing to understand are the CC&Rs. That stands for covenants, conditions, and restrictions. And let me be clear, this isn't just a neighborly suggestion pamphlet. It is a rock-solid, legally binding contract. When you buy a home in a community like this, you sign on the dotted line, agreeing to play by these rules. It's the Bible for the whole neighborhood. Next up, we have this legal concept called burden of proof, and this is huge. Since Mr. Audette was the one suing the HOA, the responsibility, the burden, was on him to prove his case. Think about that. The HOA didn't have to prove they were being reasonable. He had to prove they were being unreasonable. So, how strong did his proof have to be? Well, the legal bar here is called a preponderance of the evidence. Now that sounds fancy, but it's not like in a criminal trial where you need proof beyond a reasonable doubt. It's much simpler. It just means you have to tip the scales, even just slightly. Is it more likely than not, say 51% likely, that your claim is true? That's all he had to do. So, did he convince the judge? Was it enough? The verdict came down, and it was a firm no.
The judge found that Mr. Audette simply failed to meet that burden. The HOA won the case.
So why did he lose? It really came down to two things. First, the judge looked at the HOA's decision and said, yep, this lines up perfectly with your written rules. The 3-foot height limit was right there in black and white. But the real nail in the coffin was the selective enforcement claim. Mr. Audette showed photos of other violations, sure, but he didn't bring any proof that the HOA was ignoring them. He couldn't show that they weren't already sending out notices or taking action. And that's a huge lesson, right? If you're going to accuse your HOA of being unfair, you better come with receipts, not just pictures.
And that's what this whole case really boils down to, isn't it? It's this constant tug-of-war we see in neighborhoods everywhere. It really makes you think. Where do you draw the line between having the freedom to do what you want with your own home and the harmony of the entire community? When you sign up to live in a place with a shared set of rules, what are you really agreeing to? There's no easy answer to that one.